Attorney Siobhan Olivero. Today I'm going to be answering a frequently asked question that I get a lot, which is, should I blow or not blow when I am pulled over for a DUI? So this is probably one of the most commonly asked questions that a DUI attorney gets. And the answer is not a simple yes or no. There are several factors to consider, like, have you ever refused a breath test before? How many drinks have you had that night? And how a driver's license suspension might affect you. But in general, here's my answer to the question. You should blow if you have not had anything to drink, or maybe like one drink at dinner. Beware, however, that if you have had anything to drink, that your judgment may be impaired and you may not be as sober as you think you are. Do not blow, however, if you have had anything to drink more than maybe like one drink at dinner. It's important for you to know that a law enforcement officer cannot ask you for a breath sample or to blow unless you have already been arrested for the DUI. So that means that you've already been arrested, you're going to jail for suspicion of DUI, whether you blow or not. You can't be unarrested depending on the results of your breath test. So why would you blow then if you've already been arrested? Let's talk about the pros and cons of refusing to blow. What are some of the pros of refusing? Well, if you refuse, there is a better chance of getting your DUI charge dismissed or a reduced charge for it. If you don't blow and if there is video of field sobriety exercises and you look good on that video, then that helps your attorney potentially get the charge dismissed or reduced. It does not guarantee that you're going to get your charge dismissed and beat a DUI conviction. However, it does give the prosecutor less evidence to use against you at trial. If your case is dismissed or the charge is reduced to something other than a DUI, you also have the benefit that the charge can potentially be sealed or expunged after your case is over. So what are some of the cons of refusing? Well, there is an additional administrative suspension that can go along with the refusal. For a refusal, your driver's license will be suspended for 12 to 18 months depending on the refusal. You can possibly get a hardship or a business purposes only license for that refusal, but you're going to need to consider whether having no driver's license or whether having a restricted driver's license is going to affect you. However, if you do blow and you do blow over the legal limit of a .08, your driver's license is going to be suspended anyway on an administrative suspension. If you have refused a breath test before, so this would be your second or a subsequent refusal to a breath test, then you could face another criminal charge for the refusal. A second or subsequent refusal is a misdemeanor charge that could carry fines, probation, and possibly up to 1 year in county jail. And if you have been arrested in a county that offers a DUI diversion program, a refusal could affect whether or not you would be able to participate in the diversion program. So as you can see, the decision to blow or not blow has many considerations associated with it. But in certain circumstances, it might be worth it to not have additional evidence to give the state to use against you. So if you or someone you know are facing a DUI, whether you have submitted to a breath test or refused, contact our office so that we can review your case, see if you have any defenses, and how we may be able to assist you. So tune in next time when I answer some more frequently asked questions.